We have seen that in cases in which one person has justifiably relied to his detriment on another person's promise, contractual liability can be based on promissory estoppel, despite the fact that there is no consideration, no quid pro quo bargaining between the individuals. We have also seen that in certain instances, restitutionary remedies allow for one person to recover from another despite the absence of a contract. A restitutionary remedy is based on an obligation that arises not from a contract, but rather from one party's having been unjustly enriched at the expense of the other. One case in which restitution allows a party to recover in the absence of a contract is known as promissory restitution. Promissory restitution cases arise in instances in which one party has provided a benefit to the other party, and after the benefit has been received, the receiving party promises to pay for the benefit. This result, however, is contrary to traditional contract law. Consider the following example. Unable to swim, a wealthy man falls off his yacht and starts to drown. A fisherman in a nearby boat jumps into the water and saves the man. After the wealthy man's dried off and gathered his composure, he says, "To thank you for the wonderful thing that you did, I promise to pay you $10,000 when I return to the shore." The wealthy man never follows through on his promise, and the fisherman sues. Despite the wealthy man's promise, traditional contract law considers the fisherman's act of saving the wealthy man to be an instance of past or moral consideration that will not support a contract. A bargain for exchange is required for consideration. Each party's detriment must induce and be induced by the other party's detriment. Because the fisherman's life-saving act occurred before the wealthy man made the promise, it was not given in exchange for the promise to be paid $10,000. Thus, it is viewed as past consideration, and the wealthy man's promise is considered to be gratuitous and non-binding. More recently, however, courts have reached the opposite result in a narrow range of circumstances under the so-called material benefit rule. Courts conclude that a promise given after a benefit is conferred and which was not bargained for nonetheless should be enforced in instances in which the promisee provided the promisor with a material benefit. Despite the fact that the term material benefit does not appear in the text, Section 86 of the Restatement embodies that rule. So let's explore that section. Subpart 1 tells us that when a party who has received a benefit from another thereafter makes a promise to pay for the benefit, a court will enforce the promise to the extent necessary to avoid injustice. Let's consider an example. While John Doe is on vacation, his next-door neighbor, Mary, decides to paint John's garage, which was in bad need of a paint job. She's hoping that she may get paid for this, but does not necessarily expect payment. When John returns, he's very grateful to Mary and promises to pay her $2,000 for her work. Assuming that $2,000 is a reasonable amount for the work done, a court is likely to enforce John's promise under Section 86. If, however, John promised in a moment of extreme generosity to pay her $10,000 for the paint job, in all likelihood a court would enforce his promise only to the extent of the fair value of the paint job. Let's look at Subpart 2 of Section 86. That section says that a promise will not be binding under Subpart 1 if the promisee conferred the benefit as a gift or for other reasons the promisor has not been unjustly enriched. Let's consider the first part. If the promisee conferred the benefit with the intention to make a gift, it is irrelevant whether or not the person receiving the gift made a promise to pay for it after the fact. There is simply no argument that the promisor was unjustly enriched in receiving the gift. Thus, justice does not require that the promisor's promise be enforced. What other cases besides that of a gift are examples of the promisor not being unjustly enriched? The comments to Section 86 provide one. If the promisee delivered the benefit pursuant to a pre-existing bargain with the promisor, then there is no unjust enrichment to the promisor in receiving the benefit, and thus no reason to enforce a promise. One assumes that both sides in the pre-existing bargain have already agreed to a quid pro quo. Consider the following example. At the beginning of the summer, Mike enters into an oral agreement with his neighbor Jeremy that in exchange for $75 a week, Jeremy will perform general yard work around Mike's house, including, but not limited to, mowing, raking, and trimming shrubs. While Mike is on vacation, Jeremy also removes a pile of debris that has been sitting in the corner of the backyard for several months. When Mike returns from vacation, he's so thrilled to see the debris removed that he says to Jeremy, "What good work. I'm going to pay you an extra $50 for cleaning up the debris." If Mike has a change of heart, a court would probably uphold Mike's decision not to pay the extra $50. If Mike can reasonably argue that cleaning up the debris was well within the scope of Jeremy's agreeing to perform general yard work, then Jeremy's work was covered by a pre-existing bargain. Finally, in subsection 2, subsection B, in effect reiterates what we've discussed in the context of subsection 1, that to the extent that the value of the promise is disproportionate to the value of the benefit received, the judge does have discretion to enforce the promise only to the extent of the fair value of that benefit.